Okay, just so you know, today is Wednesday, February 5th, 2025, and we are actually recording this call. So if you don't want to be on the call that's being recorded, then now is your time to exit. But we are recording the call, and this call is strictly for knowledge purposes. All right. With that being said, I first want to thank our ancestors for bringing us together and giving us the ability to to commune, building this community. you know uh in every essence of the word, community means the ability to come together as a unit to commune, and that's what we're doing. We're building a community. All right. And I'm very, very, very thankful that I was gifted and favored with that information and the mind, to not just to grasp the information, but to be able to teach the information. So I'm very thankful for that. I'm humble, to be in the midst of my brothers and sisters. You know what I mean? So with that being said, I'm about to share my screen, and we're gonna get into the information. All right. I'm gonna get off screen, and you guys, please just monitor. What's what. If you hear a little noise in the background, see who's unmuted and ask them to, to mute themselves, so we could get through this. All right. So I prepared a trust, course. All right. It's literally about 8 weeks, but we're gonna cram that into a few days. All right. And just so that you get a basic understanding of what a trust is and what trust is used for and the different type of trust. I really want you to get a more than just a basic understanding of what the trust is. You feel me? Because well, you know me, I get carried away and talk too much. So let me just shut up, and I'm gonna get into it. So I'm gonna get off camera, okay? But I'm here.
Okay.
All right, cool.
Thank you.
Let me share my screen. Share my screen. Share my screen. All right, cool. Can everybody see the screen?
Yes.
Yes, I can.
Yes.
All right, perfect. All right, let me see if I could just bring that up just a little more, maybe. All right. Okay, so this is week one, introduction to trust. The first thing we're going to learn is what is a trust. Now, you may take copious notes. However, like I said, this has been recording, so I'll post the recording in our community on WhatsApp. So you're able to go back and take your notes and do your own due diligence and do your own research. All right. Um, So the objective here, all right, is by the end of this lesson, or this course rather, you will have a clear understanding and the definition, not just from what a trust is in the present, but a historical context and fundamental principle of a trust, or just trust in general. All right. The topics we're going to cover is the definition of a trust and what's a trust in legal terms, or it's a trust is a legal arrangement where a party, a grantor, or a settler transferred assets to another party, the trustee, to hold for the benefit of a third party, which is the beneficiary. So therefore, a trust has three components. All right. If it doesn't have that, it's not a trust. The grantor, settler, all right. Um, then you have the trustee, and then you have the beneficiary. I've given examples like in a family. A family is literally a trust. That's why wealthy families protected their assets in trust. Most of us, we were just we were not taught that information. All right. So if we were to actually look at this from a family perspective, we have the father, which is the grantor, right? And then he grants the mother the seed, all right, what we call, to fertilize the egg, right? And the mother is the trustee. So she's entrusted with that seed, and she bears the child. And within that family, that child's become the beneficiary. Okay. And that's how you protect your assets. The key components of the trust, like we said, is the grantor, the trustee, and the beneficiary. And you have the trust property and the trust agreement. Those are pretty much some of the main components of a trust. From a historical perspective, history and evolution of the trust. It originated in common law in medieval England. All right, it was around that era. Development of the modern trust structure, example, family trust and corporate trust. Use of the trust in wealth, preservation, and asset protection. That is the basic use of the trust. All right, the basic principle of trust law. Please. Okay, so if you get on the call, just mute your volume, please, so we don't have the distraction. All right. And I don't want to stop every time and ask, for that to be done. So please just do it. Thank you. Fiduciary duty of the trustee. All right. So when we talk about a trust, especially in relation to the corporation, having everybody in a trust, therefore the people who actually creates the trust or who controls the trust, they have a fiduciary responsibility, and that's the responsibility of the judge, the responsibility of the prosecutors. They are the ones that are the fiduciaries, and having a fiduciary position, it means that they're supposed to make sure that the beneficiaries of that trust, they're taken care of. All right. So a fiduciary duty of the trustee means the trustee must act in the best interest of the trust beneficiaries, managing the assets responsibly, honestly, and with loyalty. And the people that run the corporation, they are not doing that. So therefore, they are in violation of trust law. But like I said, most of us don't know these things, so we don't know how to step up and actually hold these trustees and these grantors, okay, this that's holding these fiduciary positions. We don't know how to hold them accountable. All right. They must avoid conflicts of interest and follow the trust terms. And when we go back to the corporation again, we know a trust exists. Even when there's a case, a trust is created. All right. However, there's a conflict of interest because the judge and the the judge, the prosecutor, the clerk, they all play all the roles. You feel me? All the roles, including the beneficiary, and they switch the role and let you be the trustee when the truth is you are the beneficiary. So it's important to know these things. Separation of legal and equitable ownership. In simple terms, separation of legal and equitable ownership means that one person or entity holds the title to an asset, but another person has the right to benefit from that asset. Okay, so for instance, your driver's license is considered to be an asset owned by the state, owned by that trust. However, you are the beneficiary with the right or privilege, you feel me, to use that asset. To them, it's an asset because they're making money off of the people. So to them, it's an asset. To us, even if they're considered as the beneficiary, we're still, it's a liability to us because it costs. You feel me? So are we truly the beneficiaries of a driver's license? I don't think so, but that's what they want us to think by giving us the privilege. All right. Example, imagine you own a house. All right. But place the house in a trust. The trustee is the legal owner. So therefore, when you create your trust, it has to be somebody that you actually trust. You feel me? That's why they're called a trustee. The trustee is the legal owner. They may not be the rightful owner, but they are the legal owner, all right, that manages and control the house according to the trust rules. The beneficiary is the equitable owner, all right, because they have equity within that trust. You feel me? Um, it has the right to live. They have the right to live in the house or receive rental income from the house, because those are the beneficiaries. The separation in common trust because it allows the asset protection, tax benefits, and control distribution. You have different types of trust. Now, I may not have listed all of them, but for the most part, I think I did. All right. Different types of trust and their legal implications. Type of trust on all the way to my left. All right. You have revocable trust, and the definition that it can change or be revoked during the grantor's lifetime. The grantor is the one that's literally creating the trust. All right. So a revocable trust or a living trust can be changed or revoked during a grantor's lifetime. Key benefit: avoids probate, allows for incapacity planning. Legal implications: no asset protection from creditors. It becomes irrevocable at death. So as you could see, a revocable trust, all right, it's more accessible to creditors in terms of attacking the trust, all right, or suing the trust, all right. However, if it becomes an irrevocable trust at death, let us go look at the irrevocable trust. It cannot be altered once created. The key benefits: strong asset protection, estate tax benefits, and legal implication. The grantor gives up control over the assets permanently. So the person who creates the trust, they're giving over the assets of the trust permanently for the trustee to control legally. And then the beneficiaries, they hold the equitable benefits from that trust. Now, it says that it cannot be altered once created. There could be provisions that are made in your security agreement to kind of, give yourself a bit of wiggle room, but not too much, just so you know, all right? And you have testamentary trust, and that is created by a will. It takes effect after death, all right? That's why it's called your last will and testament. So testamentary trust, okay, is not a will, but it's created by a will. It takes effect after death. Key benefits: controls asset distribution after death. So therefore, it's not a living trust, okay? Legal implication: must go through probate, and it does not, it cannot avoid it, all right? So is that a good trust to have? Not the best, right? But people still use it and they find benefit in those type of trust. Then you have asset protection trust. Shields asset from creditors and lawsuits. Key benefits: protects assets from legal claims. Legal implication: must comply with the legal restrictions to avoid fraudulent transfer claims. All right, so whenever you're dealing with trust, you have to make sure you keep literally acute records when it comes to dealing with trust, all right, just in case. And you want to make sure every transfer in any type of trust, I would say, whenever you transfer or you fund the trust, you want to make sure you have your documents to show that you did that. You don't want to fund your trust, illegally, so to speak, all right? You have charitable trust, which is, it benefits a charitable cause or an organization. If you have a community program and you're doing something for the children or something in your church or whatever the case is, you could literally do that through a charitable trust. What are the key benefits? It provides tax deductions and estate tax benefits. Legal implications: must meet legal requirements for charitable status. All right. Special needs trust. Support a disabled beneficiary without affecting government aid. All right. So basically, special needs, of course, it says what it is in the trust. If you have special needs children, all right, then you're able to create that trust for them without affecting the government aid that they're getting. You feel me? Because a lot of times people have situations, they are special needs children, and then a certain altercation in their life happens, and all of a sudden they're losing that benefit. It happens. I've heard of it, right? However, if you have that special needs trust, no matter what happens, that child, okay, is protected in that trust without losing the aid that they're getting from the government. All right. And here's the thing: it's okay to have different kind of trust. You don't necessarily have to have one trust. I mean, there are people who got 3, 4, 5 trusts, 6 trusts. All right. So there's nothing wrong with that, just so you know, because each trust pretty much has a different definition or a different purpose. You feel me? All right, cool. Key benefits: it provides tax deductions and estate tax benefits. Must meet the legal requirements. We already said that. Special needs: it preserves medical and SSI, Social Security interest, eligibility for the beneficiary, which is the disabled child. It must follow strict rules to ensure compliance with the government program. Drift trust restricts the beneficiary's access to trust funds. So therefore, in a spindrift trust, if you're not too sure about the mental capacity of the beneficiaries, you don't really trust them per se, but you want to make sure you leave them something. Well, a spindrift trust would be one of the options to also have, because it restricts the beneficiary's access to the trust funds, because you want to make sure they don't misuse the money or do crazy things with it, and then you cannot create that legacy and break that family curse of being broke, poor, and disgusted. You know what I mean? So you want to make sure that they don't, go overboard. So that's a good thing to have. It prevents reckless spending, protects assets from creditors as well. All right. The beneficiaries cannot sell or pledge trust assets. So therefore, if you want to create a legacy that's also a trust with special provisions, all right, apart from the other trusts that you have, a spindrift trust is a good option. Dynasty trust. Okay. For those of you, maybe I'm telling my age, but I remember the TV show Dynasty, right? That was a trust. They were teaching you about the family protecting the legacy, but most people look at it as entertainment. But when you know, you know. So therefore, it's designed to pass wealth across generations. You heard about JR or Sue Ellen passing down, the ranch, or the whatever the case is, the land, the animals. You feel me? So that's a good trust to have. Dynasty trust creates legacy. All right. It avoids estate taxes for multiple generations. So if you want to protect your assets, and you're looking at longevity, then that's a good trust, because why? Once again, it avoids estate taxes for multiple generations. So a house that you have in your family could go in that type of trust, and you're going to pay little or no or nothing, pretty much, all right, for generations to come in terms of estate taxes. See, people, we're not being taught these things. So when old people have their homes, they fall on hard time, they can't pay the taxes, they lose their homes. And you'll be surprised to see the amount of people that have lost their homes for less than $1,000 because they couldn't afford the taxes. All right. It is subject to generation skipping tax, GST rules. And I'm going to break down exactly what that means. But it is also subjected to generation skipping tax because of the type of trust it is. Okay. Ecclesiastical trust, a trust created under religious or spiritual law, often for faith-based or indigenous governance purposes. And that's why our republic, I created an ecclesiastical trust, so that we have a level of protection that's really hard to infiltrate. You know what I mean? So that's powerful as well. It can provide legal protection for the church assets, sovereignty, and exemption from certain laws. Must be properly structured to ensure recognition by courts, and authorities may face legal challenges if not properly established. All right. So whenever you create your trust, make sure, at least it's okay to have an attorney look over it if you so choose to. All right. Just so you know. What are the GST tax rules? The GST tax rules refer to the Generation Skipping Transfer GST tax, which is a federal tax in the U.S. Designed to prevent wealthy individuals from avoiding estate taxes by transferring wealth directly to their grandchildren or future generations. Because people do that sometimes. However, what they do is they would, instead of trying to pay the taxes, they would just pass it on. Now you could do that and avoid some taxes, but at some point, even if it's after a few generations, they would come and investigate, and the beneficiaries would have to pay some taxes on that. But it skips a few generations, just so you know. It's not indefinite. All right. Key points of the GST tax rates. 1, applies to skip generations. This tax applies when assets are transferred to a grandchild or anyone at least 37.5 years younger than the giver, bypassing the giver's children. All right. 2, flat 40% tax rate. The GST tax is separate from the estate and gift tax and has a flat rate of 40% on transfers above the exemption limit. So there's always an exemption limit. That's something that you're going to have to look into if you have that type of trust. There's always an exemption limit. If it goes over that, then whatever it is, they start taxing that. All right. Lifetime exemption. As of 2024, the GSA exemption is literally 13.61 million per individual. So I'm just saying, you know what I mean? After that cap of 13.61 61 million, that's when that 40% kicks in. So is it a good trust to have? Absolutely. You feel me? Because lifetime exemption as of 2024, which is just recently, the GST exemption is literally 13.61 million. So if you have up to that in that trust, all that is tax exempt per individual. All right. Now transfers under this amount are tax free. So anything under that 13.61 million, anything under that that's transferred to the beneficiaries, guess what? It's tax free. How beautiful is that? 4, irrevocable trust and GST. If assets are placed in a dynasty trust, they can be protected from GST tax for multiple generations if properly structured. Number 5, direct skips and indirect skips. The tax applies to both direct gifts to a grandchild and indirect transfers through a trust benefiting a skipped generation. All right. Example of how GST tax works. First example, a grandfather leaves 5 million directly to his grandchild. Since this is below the 13.61 million exemption, no GST tax applies. All right. Number 2, a wealthy individual transfers 20 million to a trust for future generation. The first 13.61 million exempt, but the rest, which is 6.39, it is taxed 40%, resulting in about 2.5 million GST tax liability. It's a lot of money. All right. It's like 2.56, having the government take that away from your children is a lot. All right. So what I would do, and again, I'm not telling you that to evade taxes, I would not give each beneficiary no more than that 13 something. You see what I'm saying? I would just do that to kind of stay below that exemption, and then give another beneficiary or create another trust where they could literally be the beneficiaries of that other trust. And of course, this is by no means giving you that information for tax evasion. All right. How to avoid or minimize GST tax. Use a dynasty trust. Properly structured irrevocable trust can help shelter assets from GST tax for multiple generations. Leverage GST exemptions. Make sure to utilize the lifetime GST exemption, like I said, effectively when planning large wealth transfers. Annual gift exclusion. Gifts under 18,000 per recipient, which is 24,000 limit, are exempt from GST tax. So therefore, you could give the beneficiaries literally as gifts. All right, anything under $18,000 as of 2024, those are exempt. And that's how wealthy people protect themselves, and that's how wealthy people keep what they have, because they create those type of trust and they give gifts. All right. Spousal transfers. GST tax does not apply to transfers between spouses. So if you have a spouse and you transfer such and such, boom, that falls under that does not meet the criteria for that GST tax. All right. And by no means this is legal advice. I'm just giving you the information. I would suggest, if you need professional consultation, okay, consult an attorney. All right. I'm just making my disclaimer because this call is being recorded. Last but not least, the GST tax rules primarily impact high net worth families looking to pass wealth across multiple generations. Proper estate planning with trust and exemptions can significantly reduce or eliminate this tax burden. All right. And there are ways of doing that, the way you structure and the team that you have around you. Ecclesiastical trust, legal function and use in sovereign matters. An ecclesiastic trust or ecclesiastical trust is a trust established under religion, spiritual or indigenous law, rather than statutory law. These trusts often serve to protect assets, maintain sovereignty, and operate outside typical legal jurisdictions. Once again, may I reiterate, that's why we have one, all right, because we also have a ministry. You feel me? The republic has a ministry, and the republic is a republic. So that works out perfect as being indigenous and also have its church aspect. You feel me? I'm still tightening up, doing some more work on it, but we already have the EIN for that and everything. So I'm just tightening everything up before I go open up the bank account for that. All right. Before we'll break down their purpose, benefit, legal functions, and challenges. Number one, purpose of an ecclesiastical trust. Faith-based asset protection protects church ministry or indigenous assets from government interference or taxation. Sovereign and self-governance, used by indigenous nations or religious organizations to manage property under spiritual law. Spiritual law is higher than statute laws. You feel me? Non-statutory trust structure operates outside traditional statutory trust laws, often governed by religious doctrine or common law. Ministry and humanitarian work allows a religious or indigenous entity to provide services, housing, and financial assistance without their community. Number two, legal functions of an ecclesiastical trust operates on the canon ecclesiastical or natural law, may be structured based on church doctrine, indigenous governance, or private trust law. Trustees act as the stewards, not owners. Trustees are never the owners, okay, in that type of trust. They're just stewards, all right? Guardians, if I may. The trustees manage assets, but do not own them personally, preserving the trust sovereignty, okay? So preserving the trust sovereignty, it can be private, it can be private and unregistered. You feel me? Some ecclesiastic trusts avoid state registration to maintain privacy and autonomy. So for me, I would not register that trust. I'm not going to do that. However, when I got the EIN, it was only for banking purposes. Only for banking purposes. I create my documents, I go to the bank, and boom. The state, the federal government ain't got nothing to do with anything. And stuff is protected in trust. I'm giving y'all game. All right? Recognized by the international law and indigenous rights. If properly structured, it may gain recognition under religious freedom protections or treaties. It's a beautiful thing. Benefits of the ecclesiastical trust. Tax-exempt status. In some cases, assets held in an ecclesiastical trust may qualify for tax-exempt treatment. But we already have a ministry, so we automatically tax-exempt. You see how I covered all bases? Asset protection. Assets are separated from individual ownership and protected from lawsuits, liens, and government seizure. My brothers and sisters, pay attention. You see, paying attention is free, but you still got to pay because you got to pay attention. You feel me? Spiritual and indigenous sovereignty used by religious organizations or indigenous nations to govern independently from civil law. Long-term wealth preservation can safeguard assets for future generations, similar to a dynasty trust. Legal challenges and considerations must be properly structured because they're going to look for the loopholes, right? If not legally sound, courts may refuse to recognize the trust. So they're going to look for the loopholes because they know how powerful the ecclesiastic trust is, like pretty much one of the highest protection trusts on the planet because it deals with natural law. It deals with universal law. It deals with indigenous law. All right. Government and court recognition varies. Some jurisdictions do not acknowledge ecclesiastical or sovereign trust as separate from statutory trust, but that's their problem because we're indigenous. All right. So it's all love. It cannot be used for fraudulent purposes. Misuse, example, tax evasion or fraudulent claims of sovereignty can lead to legal action. So you have to clearly, definitively, all right, in your declaration, in your deed of trust, you have to lay down the intent of the trust. It cannot be to evade taxes. Okay? It may require international or tribal recognition. We have a republic, so therefore it's recognized by the republic. If tied to indigenous governance, additional legal steps may be needed for all protections. Ecclesiastical trust and sovereign movements. Ecclesiastical trusts are often used by churches, ministries to protect religious assets, establish private membership, all right, associations, and operate under spiritual law. Indigenous nations and tribes to assist sovereignty, manage land, and create financial independence from state control. Private families and organizations to secure multiple generational wealth under religious or common law jurisdiction. All right, discussion and questions. How do trusts differ from wills and other estate plan tools? So we went through what is a trust. All right, we went through various type of trust. Okay, and we literally spoke about the most powerful, if not one of the most powerful trusts that exist. Okay, which is the ecclesiastical trust. Right now, we're gonna look at the differentiation between wills and estate planning tools. All right, here we go. So the answer for this is trusts differ from wills and other estate planning tools in several key ways, and we're gonna lay that out right now. For for simple operation chat below, highlighting the key differences between trust, wills, and other estate planning tools. So here we go. So we have trust to my extreme left, and we have wills in the middle, and we have other estate planning tools to the far right, power of attorney, joint ownership, etc., etc. Okay. Now we have the probate process. Okay. Avoids probate, must go through probate, and varies. POA is a power of attorney. It ends at death. Joint ownership may avoid probate. I always encourage individuals to have a power of attorney, somebody that you trust, to give power of attorney just in case you get into a situation and you are not able to handle your affairs for whatever reason. That person, that individual is on the outside. Okay, and you could put your provisions in that power of attorney, limit certain powers that they have, right? So you could literally lay that out in your power of attorney. Okay. Privacy, privacy. All right, private. Which is one of the features of what you call it. The give me 1 second. Let me just go back here for a second. So the trust. The private, it becomes public record because you have to put for comes to the will, it becomes public record. The trust is private. Wills have to go on the record and it's public. You don't ever have to put your trust in the public. Your trust is always private. That's why it's called a trust. All right. When I go back once again to the Garden of Eden, the allegorical Adam and Eve, they were private until they went into public and exposed their trust, exposed themselves to the public, and put it on the public record. And the allegorical God in the Bible came and said, hey, here's the fig leaves, go back into the private. Stop exposing your privates, all right? Now, depends on tools used. All right, in terms of other estate plannings and power of attorney, you could kind of finagle your way. All right, control over the assets can specify how and when assets are distributed. When it comes to wills, distribute assets in a lump sum. With a trust, it could be different. It doesn't necessarily have to be in a lump sum. It could be distributed in many different ways. Okay. Various POA, which is power of attorney, allows control while alive. Joint accounts give control to co-owner. Incapacity planning. In a trust, it provides management, and the grantor is, if the grantor is incapacitated, some trusts offer advantages, right, for the tax benefits. However, the wills does not provide incapacity planning and no direct benefits when it comes tax benefits when it comes to wills. All right, power of attorney can manage assets during incapacity. All right, depends on the strategy used. So everything is about strategizing and what complementary documents you want to use for your trust and you want to use for your wills, and they're called tools. Okay. Flexibility. Revocable is changeable. Irrevocable is permanent. Or in a will, it can be changed it can be changed until death. So wills could be changed until death. But in a trust, there's two categories: revocable or irrevocable, and you decide what type of trust you have and the purpose of the trust, and you decide whether it's revocable or irrevocable. However, for a will, you could do your will today and change it next week until you literally meet your demise physically, and you could do that with a will. All right. Varies for the power of attorney is changeable. Joint ownership is harder to alter. So within any of them, whether it's a trust or a will, if there's joint ownership, of course, there's more paperwork to do. But if it's just a power of attorney, you could change at any time. Because you could change your mind and say, listen, man, you know what? I don't want you to be my power of attorney, no more. Or you could give your power of attorney a certain amount of time to be the power of attorney. All right. And if you want to go ahead and write another one, then you could do that. Just so you know. You just don't want to give somebody power of attorney, for the rest of your life and not regulate that power of attorney. Okay. Now, the features, the trust and the wills. Legal cost. The trust, higher initial setup cost, right? It saves probate fees. So up front, you are saving money with the trust. That's why trusts are so expensive. So up front with a trust, it costs you more. But in the end, it saves you more in probate fees. I'll give you another example. If you eat healthy, you know what I'm saying? It may cost you to eat more healthy, but in the long run, you live longer. With wills, it costs lower upfront, but it costs more in probate. So if you eat bad, now it's going to cost you more in the end because you got to pay bills when you get sick. You feel me? So with that being said, you decide whatever works for you. Of course, you could have both of them, but I'm just giving you the differences, all right? And when it comes to the tools, it varies based on the type of tools that you use, okay? Why have the trust been historically used to protect wealth? Trusts have been used for centuries as legal tools to protect and manage wealth across generations. Here's why. Number one, asset protection. My brothers and sisters, we were not taught these things. At least I wasn't taught that. I can't speak for everybody. All right. I wasn't taught that as a child. And I've done extensive research and talked to people about these things, and they didn't even know these things exist, that they could do these things. Some people didn't even know what a trust was. Just recently, I was talking to some people about trust. They didn't even know what I meant about that when I spoke about trust. So that's why we're out here and there's no generational wealth being passed down, because everybody's just willy-nilly spending everything they got. All the, the mother and father they don't know about trust. So the beneficiaries out here, with nothing. So we are changing the dynamics and the paradigm of the way we do things by learning. Okay, each one teach one. Asset protection. Trust shields assets from creditors, lawsuits, and financial risk. 2, tax efficiency. Many trusts help minimize estate taxes, capital gains taxes, and generation skipping transfer through GST taxes. We already went over that. All right, number 3, wealth preservation. Trusts ensure that the wealth is managed and distributed according to specific terms, preventing reckless spending. Number 4, avoiding probate. Assets in a trust bypass probate, providing faster distribution and privacy compared to a will. How many of us could actually relate to that? When a loved one passed, there was no trust, then we got to go to probate. Even if there's a will could be contested because it got to go to probate. And when it goes to probate, the state takes 33 1/3%, and the rest, the family got to fight for it. You see, we got to stop the madness. If we want change, we got to learn how to make change. And we have to learn how to apply the change. And that's what this is all about. Generational wealth transfer. Dynasty and irrevocable trust allow families to pass wealth tax-free for multiple generations. Number 7, protection from government seizure. Certain trusts safeguard assets from government claims, lawsuits, and divorce settlements. Game. Historically, royal families, you hear that? Royal families and aristocrats and wealthy individuals. That's why we were not taught these things, because they wanted us to be exposed in the public. They did not want us to stay in the Garden of Eden, so they had to kick us out. Because in the Garden of Eden, you had your sovereignty. In the Garden of Eden, you was in the private. But the government is playing God and got everybody in the public exposed, being abused. So we got to learn to go back into the garden. You feel me? So these individuals, they have used trust to maintain control over their fortunes and ensure long-term financial sovereignty for their heirs. So when you hear the term trust fund baby, you know what we are talking about. Generational wealth. Now, exercise, right? Research and summarize one historical case involving a trust and its legal impact. So you could do that on your own. Go ahead and research families that have had those trusts and see the legal impact that it had. It was literally little to none. You feel me? Because they protected their assets. They make sure that they did not pass on debts to their children. And that's what a lot of us have done. When we go in our house, our homes, our houses, right? And we look on the wall, we don't see pictures of great-great-granddaddy or great-great-grandma and say, well, hey, this is what they passed down to us. No, it's always a bill. It's always, some debt. We got to change that. And that's how we do these things, by protecting what we have. I don't care how small it is, protect it. Why create a trust? Asset protection, estate planning and wealth transfer, privacy and confidentiality, tax benefits, avoiding probate and court interferences. All right. Domestic versus offshore trust, U.S. trust, international jurisdiction. Okay, because you could also have offshore trust. That is another strong form of protection. Trust can be established domestically within the U.S. or offshore outside of the U.S., each with distinct legal, financial, and tax implications. Let's start with domestic first. Domestic trust, U.S. trust. A domestic trust is one that is governed by the U.S. law and is subject to U.S. regulation, taxation, and court jurisdiction. The key benefits: familiar legal system, so it's easier to enforce under the U.S. laws. Tax reporting simplicity, no need for foreign assets disclosures, unlike offshore trust. State-specific benefits. Certain states, example, Delaware, Nevada, South Dakota, and Alaska, they offer strong asset protection on private laws, on privacy laws. So Delaware is, especially Delaware. A lot of people don't know that. All right, so boom, game. But here are the downsides, right? Less asset protection because they are being governed under the corporation, right? U.S. trust can be subject to lawsuits and creditors and judgments. Next, no tax shelter benefits. Income from U.S. trust is still subject to U.S. taxation. Number 2, offshore trust, international trust. An offshore trust is established in a foreign jurisdiction, often tax-friendly, or asset protection havens such as the Cayman Islands, Belize, Cook Island, or Switzerland, and I forgot to put Brazil here as well. All right. Now, the key benefits: superior asset protection. Offshore trusts provide stronger legal protection against lawsuits, creditors, and government claims because it is international, it is foreign. So it's away from the jurisdiction. You feel me? Tax advantages. Some jurisdictions impose low or no taxes on trust assets. Increased privacy. Offshore trusts often shield assets from public records. The downsides to that. The first one, complex tax compliance. U.S. citizens with offshore trusts must comply with the IRS reporting, i.e., example, the FATCA and the FBAR filing. If you're interested in learning about those things, make sure you do your research on that to see exactly what they are so you are actually in compliance. All right. Next, costly setup and maintenance. Offshore trusts require higher legal fees and annual cost. Next, potential legal challenges. U.S. courts may still enforce judgments against trust assets under certain conditions. So you have to make sure you're airtight and do your due diligence when it comes to offshore trust. All right. Number 3, tax implications and legal considerations. U.S. trust, tax on worldwide income. Grantor trusts are taxed to the grantor. Non-granted trusts are taxed separately, subject to estate tax up to 40% if the trustor is in the U.S. So therefore, the grantor is always responsible for the trust. All right. And when I was thinking about that, I came up with, man, I'm telling you, the way my mind works is I just can't, well, you know what? Let me don't, tap myself on the shoulder like that. But what I was thinking, right, with the trust that I create, so I'm going to have to do an amendment, so I was thinking with the trust that, I created and I've created for people so far, we are the grantor, which is the executor, and the trustee and the beneficiary, right? But what I'm going to do is I'm going to make the straw man the grantor, because I put all the names in upper and lower case to also implicate and show that we are separating ourselves from that entity, because by right, it is the grantor, because we are supposed to be the beneficiaries of everything of that capital name, because it is the debtor, it is the slave. And that slave is supposed to obey its master as it obeys the God in heaven. I'm putting y'all onto game, really telling y'all what the Bible is really about. You feel me? That is the slave. It's supposed to work for you, not you work for it. You did. So I'm going to go back into trust. All right. For those of you who have created your trust so far, we could do an amendment if you already open up your bank account. If not, I will deal with that. Just go back and just make sure that the grantor is the all caps without your AKA indigenous name. But the trustee is your upper and lower case with your indigenous AKA name. Man, I'm telling you, when that came to me today, I said, yes, thank you, ancestors. Gotti. Oh man, I'm telling you, this is beautiful. Certain states, etc., Nevada, Delaware, allows asset protection trust with favorable tax treatment. Offshore trust. Most must comply with IRS reporting, like we said before, and with the forms 5220 and 3220-A, and you have the FBAR and the FATCA, etc. Offshore trusts don't eliminate U.S. tax liability if the grantor or beneficiary is a U.S. citizen. All right. So once again, the grantor, if it's a U.S. citizen, you feel me? Then they are literally still liable. All right, for what you call it, for the tax liabilities. Also, the beneficiary of the United States citizens. Okay. Now, it can reduce estate and income tax burdens if structured correctly, all right, i.e. using foreign non-grantor trust, all right? My final thoughts on which trust is best. Use a domestic trust if you want simplicity, U.S. legal protection, and easier tax compliance. Use an offshore trust if you need maximum asset protection, privacy, and potential tax advantages while ensuring compliance with IRS rules. Now, this I have here for week 2, but I'm gonna be on here I'm gonna do week 2. We just did week 1. I'm gonna do week 2, and then we could probably stop, because I have this all the way up to week 8, up to lesson 10. All right, so this is just the introductory. you know, and we'll get a little deeper into it. All right, but we're not going to be on here for 2-3 hours tonight. All right, so we did week 1, we did lesson 1, lesson 2. This is lesson 3, week 2. So we're going to go through that, and then I think we could take a hold. All right. Now, key components of a trust. The 5 essential elements of a trust. You have the grantor, the settlor. That's the one who creates the trust. You have the trustee who manages the trust. You have the beneficiary who benefits from the trust. You have the trust res, corpus, which is the body, because corpus means body, right? The assets held in the trust or the body of the trust. And you have the trust agreement, the deed, the declaration, the certification, etc., and the governing documents. Example, certification of trust, you know, and what else? You may have a resolution for the funding of the trust. So all those things are just supporting governing documents. Okay. Now, in understanding or overstanding trustee rules and responsibilities. A trustee is the individual or entity responsible for managing the assets within a trust on behalf of the beneficiaries, according to the terms set by the grantor, trust creator. Trustees have legal, financial, and ethical responsibilities that require careful management and decision making. So when you're creating your other trust, you want to make sure that you find a trustee, that's someone that you could trust. Hence, the word is called trustee. Very sensitive. Number 1, fiduciary duties of the trustee. A trustee owes a fiduciary duty to the beneficiaries, just like how the courts, the judges, the clerk, the prosecutors, they hold a fiduciary position, and they owe, okay, absolute duty to us, the beneficiaries, meaning they must act in the best interest of us, which is the, you know, of the trust, and its beneficiaries, which is us. And that duty includes a duty of loyalty. This court people are not loyal to us because they are charging us, because they are making us the trustees when we are the beneficiaries. That's why the first class was literally teaching you about the Cestui Que Vie Trust, how it all happened, and what the courts are doing. And here you go now, learning about the trust, how to protect yourself and position yourself. Okay? A, duty of loyalty. The trustee must act in the best interest of the beneficiaries, avoiding conflicts of interests. That's not what the judge is doing. That's not what the prosecutors are doing. All right? They cannot use the trust assets for personal gain, and that's what they are doing, because the trust was created for you as the beneficiary. You feel me? Or favor one beneficiary over another unless authorized by the trust. Do you know the fine prints that's in that trust that you are in? No, you don't. So you always have to let them know that you are the beneficiary to avoid any complications. Because you don't know what your mother signed. You don't know what information she gave them. All you know is you are the beneficiary, and that's all you need to know. B, duty of the prudence. The trust must manage assets responsibly as a prudent investor, making sound financial decisions. Investments must be diversified to minimize risk. That's why you have to have a trustee that you could trust. C, duty to follow the trust terms. The trustee must adhere to the trust document, ensuring assets are distributed correctly. They cannot change the trust terms unless explicitly authorized. D, duty of impartiality. The trustee must treat all beneficiaries fairly, balancing their interests. They cannot favor one beneficiary over the other unless the trust dictates otherwise. E, duty to keep records and provide accounting. Trustees must maintain clear financial records of all transactions. You want to make sure that your trustee is competent. Just in case there's a legal situation, the trustee could go back to such and pull such and such receipts out to cover the beneficiaries or even the trust. At that point, it's not the grantor. The grantor relinquishes all power or ownership of the trust, and hands it over to the trustee. All right. The trustees may be required to provide an annual report or accounting to the beneficiaries or the court if the beneficiaries so request that. Number 2, legal liabilities of a trust. A trustee can be held liable if they fail to fulfill their fiduciary duties. Common legal risks include, before we go into that, let's read that again. A trustee can be held personally liable. The reason why I'm going over that again, and I'm getting tongue-tied because I got excited, all right? If they fail to fulfill their fiduciary duties, and that's what the courts are doing. So therefore, we should hold them liable for not making sure that the best interests of the beneficiaries are kept. But because you don't know you are the beneficiary, you are acting as the trustee, and therefore you are the one paying. You bear the liability to them because they made themselves the beneficiary. Now I hope it's all coming to light. A, breach of fiduciary duty. If a trustee mismanages the funds, engages in fraud, because that's what they're doing, or fails to follow the trust terms, they can be sued by the beneficiaries. Why aren't we suing these judges? I keep telling people, man, listen, community, unity, let's build, and when we come in hard. I'm not just doing that because I'm bored. I'm not just doing these lessons because I'm bored. No, I'm doing this for a reason. So we could learn, we could sharpen our skills, we could sharpen our tools. Iron sharpen iron. Because when we step up, I want everybody to be on the same page. We should have learned our lessons that it can't be just one man or one woman with all the information or the pool. When they take that individual out, we fall back 50 years now. I want everybody to have my mindset in terms of the information. So I'm giving it to y'all. Example, if a trustee improperly invests trust assets and causes losses, they could be held personally responsible. B, failure to pay taxes. Trustee must ensure trust taxes are paid, i.e. income taxes and estate taxes. These judges, these people, they don't pay taxes on what they do on us. So why don't we make sure that they pay taxes? There are ways of doing that. Sending certain forms to the IRS with their names on it, with the docket number, to make sure that they pay their taxes. Because they're not supposed to be doing what they're doing. And we'll expose them being the beneficiaries when they're not supposed to be. Failure to file tax returns or misreporting can result in IRS penalties. Wake up. C, conflict of interest and self-dealing. A trustee cannot engage in transactions where they personally benefit at the expense of the trust. That's what they're doing. Example, if a trustee sells trust assets to themselves below market value, it is a breach of duty. Or if trustees, you see what I'm saying, take the assets from the beneficiary and for themselves, that is also abusing and a breach of their duty as a fiduciary position. Improper distribution of assets. If a trustee distributes funds incorrectly or before debts, taxes are settled, they are to be held liable personally for losses. Anytime there's a court case, you are the beneficiary. You are the one that's supposed to be getting paid, not them. I hope I didn't say too much. Number 3, trustees selection process. Choosing the right trustee is crucial for the proper trust administration. Trustees can be individuals or institutions, such as banks or trust companies. When you use an individual as a trust, as your trustee, here are the pros. We're going to give you the cons as well. Often more personally familiar with the beneficiaries, may charge lower fees than corporate trustees, may be more flexible in terms of flexibility in handling the trust matters. Here are the cons. Risk of mismanagement if they lack financial expertise. A lot of our people were not taught financial literacy, right? Could become biased in family disputes. Before you know it, you got, cousin Ray Ray and cousin Pookie using all the money in the trust to go turn up. That could be a problem. May face conflicts of interest. Example, if they are also a beneficiary, because they might want to take it all for themselves. Using a corporation, we got pros and cons as well. The pros, okay, such as banks, companies, law firms, etc. Pros, professional expertise, experience in trust administration and investments, impartial decision making, avoiding family conflicts, provide continuity. Institutional trustees don't die or become incapacitated. And the cons, all right, higher fees than individual trustees, may be less flexible in handling unique family needs, and can be slow in decision making due to corporate policies. So you would have to determine, once you start going to another level, if you want to use one of your family members or somebody else to be your trustee and deal with the cons, or you could go with the bank and deal with the cons as well. But I'm certainly sure it's something that could be worked out. You just have to do your due diligence to find a bank or a company or whatever the case is that has a little more flexibility when it comes to corporate policies. All right. Co-trustees. A trust can have multiple trustees to balance responsibilities. Example, one family member trustee for personal understanding, one professional trustee for financial expertise, right? So you could have 3, 4, 5 trustees if you want. Okay. Final thoughts: choosing the right trustee. When selecting a trustee, consider financial and legal knowledge for trust management, impartiality to avoid conflicts, longevity and reliability for long-term and trust administration, willingness to serve. Being a trustee is a serious responsibility. All right. Here's a comparison table to help with trust selection criteria. Okay, you have expertise. Individual trustee may lack financial, legal knowledge or less experience. Corporate trustee, more professional. All I did was, and you have a co-trustees combine family and professional, so you could kind of mix it up as well. All right. Impartiality, you'll have a little more bias when it comes to a family member. Impartiality when it comes to decision making for a corporation. Now you could have a balanced approach and use both in a sense, right? Although conflict may arise because the corporate trustee may have a different, concept with the personal trustee. So I wouldn't do a co-trustee in the sense of when it comes to dealing with, impartiality. All right. So you're going to have to kind of work with that. We already talked about the cost. We already talked about continuity. I just broke it down in a chat. All right. And we have risk management when it comes to the family, higher risk with a bank or corporation, lower risk with professional ones, they're more involved. All right. Conflict of interest is more potential with the family. Personal is not personal with the business. Okay.
Stop.
Yeah.
Stop doing that. So you get in trouble.
I'm sorry. Could you mute yourself, please? All right. So best trustee choice based on situation. For small, simple trust, individual trustee, example, responsible for family member, that is the best way to go. For large or complex trust, corporate trustee for professional management is the best way to go. For family trust with a wealth management needs, core trustees balance between family understanding and professional expertise. All right. We are going to stop here. Tomorrow evening, we could do the next class and continue with week 3, lesson 4. But we're going to stop here for now. I'll make sure that this video is available for everyone after it downloads and whatever the case is, and it is saved. So before I even end the live, I'm going to try to make sure that it's saved. All right, because I don't want to lose it. You feel me? So thank you for being a part of the first class of the the trust class. And like I said, we'll continue tomorrow evening Well, I'll make that determination tomorrow, but most likely we'll do it tomorrow evening. With week 3, lesson 4. Like I said, it's all I got it all the way up to I think week 10, I think, or 8 to 10. But we're gonna run through that. All right, we're gonna run through it. All right, cool. Let me go ahead and stop sharing and get back to the call itself. Go ahead and stop sharing. Stop sharing. And I guess I could stop recording. All right, I could, or maybe if anybody have any questions, let me get back on camera. I guess I could leave it record. It's going to be recorded. So anybody have any questions, concerns, comments, or anything like that?
I don't know if I can throw away or not because.
No. Thank you for your energy because that was a lot of reading.
Yes, yes.
That was very good.
That's what I
yes.
love to do, man. I love it. You know what I mean? So it's all good.
Question.
Very
Yeah.
informative.
Yes, go ahead.
Yeah,
So
I'm just following along, Chief, and learning more. I need to hear more. So I'm just following along. Thank you.
No, welcome. Anybody else?
Yes, I was wondering if there are any websites that we can go to in regards to sample trusts to see what they actually look like or entail.
I have no idea of websites per se, but what I could suggest is you could also go to use Chat GPT, and they could give you like a sample of a trust. You could do that as well. You know what I mean? Me, I create my trust from scratch. You know what I'm saying? Like even this document right here, it's a lot of different books and different things. I would get bits and pieces here to create the class. So you could do those, do that as well. Because at the end of the class, I'm going to ask everybody to create a trust. A very simple trust, and then during the class we'll pick everybody and they'll go over their trust and show, and and we'll see, okay, wow, and we'll do that.
Now, see, there you go with these
That
shenanigans.
works.
I'm just playing. All right, sounds good, Chief. I'm gonna do my best. I'm gonna try.
It's all good. By the time we're done, now all you have to do, because everybody's gonna get the video, right? So, but you go over it and make sure you get familiar with the information. So once you start hearing
Yeah.
trust languages, nobody could play with you because you at least you have a foundation. Does that even make
Right.
sense? You feel me?
It does.
Yes.
All right, cool.
Absolutely.
All right, cool.
Sounds good.
Yes, indeed.
I noticed something on the slide where it said the government had the certificate. I think it said the certificate they hold the certificate.
The certificate of what?
Well, the trust, it says something about the government has the certificate. I took a screenshot of it. I didn't write it down. I'll go back and look at it, and then I'll ask you about it, because I was just wondering how we actually be able to be the controllers of it and actually take back.
Well, the you talk. All right, let me just let me stop the recording. All right, so what time is it? It's 9:39, Wednesday, February was that 5th? I'm gonna end the recording right now.